So I'm gonna go ahead and play this video. Back on the Civil Rights Lawyers channel, and this is titled "Cop Slams Birthday Girl to the Pavement. Lawsuit Settles After 7 years." So after 7 years of going to court and having to deal with this, it took them 7 years to make a decision. So when everybody is like, "Oh, you need to go ahead and sue," and or reach out and get you some lawyers so you can sue, it took 7 years for them to come to a decision. So you have to know that sometimes it might take way longer. A situation where you think it shouldn't be more than a couple months could end up being years.
This girl was celebrating her 22nd birthday. Cops showed up. They ended up slamming her down onto the ground. She was injured. She filed a lawsuit. It got litigated for 7 years and all the way up to the 10th Circuit. It just settled a couple days ago.
He's not free to go, but you can keep walking. Back off. No, back off. No, man, you touch me. I don't want to throw you on the ground. Please don't do that. What did I do? Please don't do that. Hey, I'll put my hand behind my head. Put your hand up on your head right now. Hey, what the did I do? Ma'am? What did I do?
Before I give you all the answers, which I will, which will give you a better understanding of the law of excessive force and how qualified immunity applies to that, I want you to put in the comments your prediction about whether or not this is a constitutional violation, whether or not this police officer gets qualified immunity, and does this woman deserve to be paid? If so, how much? If not, why not? Let me know in the comments. All right, let's go through it. And just to be clear, the description of this video that I'm about to give you and the law as it applies to it is straight out of the federal court opinion. It's undisputed. In April 2017, Ms. Surratt was celebrating her 22nd birthday at a bar in Fort Collins, Colorado. At approximately 11:12 p.m., two Fort Collins police officers, Officer Garrett Pastor and Officer Clamser, were dispatched to the bar in response to a recorded disturbance involving Ms. Surratt's then-boyfriend, Mitchell Waltz. While Officer Pastor spoke with Mr. Waltz, Officer Clamser spoke with the bar's bouncer. Ms. Surratt attempted to exit the bar and, quote, lightly bumped Officer Clamser as she walked past him.
So I got a little bring Tyler out here. He said that he had to go tell the guy multiple times, get off and bumping into him. Tyler? Our security guy. Kept bumping into him. Excuse me.
Ms. Surratt approached Mr. Waltz and tried to walk away from the scene with him. Upon learning from the bouncer that Mr. Waltz was involved in the disturbance, Officer Clamser yelled to Officer Pastor that Mr. Waltz was not free to go.
Hey, he's not free to go. He's not free to go, but you can keep walking.
Officer Pastor began interviewing Mr. Waltz, and Ms. Surratt tried to walk towards Mr. Waltz. Officer Clamser, quote, standing 6 feet tall and weighing approximately 200 pounds, blocked the 115-pound Ms. Surratt from obstructing Officer Pastor's interview.
Back off. No, back off. No, man,
You don't need to touch me. You don't need to touch me. You don't need to touch me. Why are you touching me?
Put your hand on your head. You're under arrest. You're under arrest.
That's crazy. To be 6 feet tall and
put your hand
No, explain to me why you're arresting me. What did I do?
I don't want to throw you on the
What
ground.
did I
Please
do?
don't do that.
What did I do?
Yeah, both of
Okay,
them.
I'll put my hand behind my head.
Put your hand up on your head right now.
Hey, what the fuck did I do?
Ma'am?
What did I do?
He placed Ms. Surratt under arrest and held her by her wrist. In response, Ms. Surratt attempted to pry Officer Clamser's fingers off her arm and pawed at his arms. Officer Clamser then used a takedown maneuver, throwing Ms. Surratt to the ground to subdue her.
I don't want to throw you on the
What
ground.
did I do?
Please don't do that.
What did I do?
Please don't do that.
Okay, I'll put my hand behind my
Put
head.
your hand up on your head right now.
Hey, what the fuck did I do?
Ma'am?
What did I do?
Ms. Surratt quote sustained a concussion, cervical spine strain, confusions to her face, and bruising on her arms, wrists, knees, and legs.
I'm not resisting. I'm not resisting. I'm not resisting, please. I'm not resisting, please.
Your car here?
I'm not doing anything.
Sure.
I'm not doing anything.
I have a 276 transport card.
I was trying to get my boyfriend. Are you calling me?
Yep.
Oh my God.
After the incident, Ms. Surratt was charged with obstructing a peace officer and resisting arrest. Ms. Surratt pleaded not guilty to both charges and asserted the theory of self-defense, arguing she used physical force against Officer Clamser to defend herself, quote, from what a reasonable person would believe to be the use of unlawful physical force. The jury rejected the theory of self-defense and ultimately convicted her of both charges. In March 2019, Ms. Surratt filed a federal civil rights lawsuit alleging Officer Clamser violated her constitutional rights by subjecting her to
is it still echoing, Carl? Is the video still doing that?
excessive force during her arrest. She alleged that in making the arrest, Officer Clamser used greater force than would reasonably be necessary to effect a seizure by, among other things, pulling her arm by her wrist and throwing her face first into the sidewalk.
I don't know what's going on there.
Seizure by, among other things, pulling her arm by her wrist and throwing her face first into the sidewalk.
Oh, I see. Hold on. Let me try to do
After the lawsuit was filed, Officer Clanzer asserted
How's that
qualified
called?
immunity. The case went all the way up to the U.S. 10th Circuit Court of Appeals. They took a look at the case, they watched the video, and this was their conclusion. Ms. Surratt was arrested for 2 misdemeanor offenses committed in a particularly harmless manner. She did not pose a threat to Officer Clanzer or others after he initiated the arrest, although she did minimally resist arrest. Officer Clanzer's alleged use of force against Ms. Surratt using a takedown maneuver to slam her face into the ground was not proportionate given her level of resistance. And we therefore hold that the use of the takedown maneuver to slam to the ground a non-violent misdemeanant who poses no immediate threat to the officer or others based on minimal resistance to arrest is unreasonable and constitutes excessive force.
I wonder what's going on.
Based on minimal resistance to arrest. Excessive force.
I don't know what that is. All right. I'm testing the mic, trying to see what's going on. Can you hear me? Or does it just sound, does even my voice sound distorted when I go about this? Let me know how I'm sounding right now. Is it normal? Does it sound like any echo? Okay.
Under the Fourth Amendment. In reaching that conclusion, the 10th Circuit went over the Graham factors, which, as I've explained in numerous videos, are 3 different factors. 1, the severity of the crime at issue. 2, whether the suspect poses an immediate threat to the safety of the officer or others. And 3, whether she is actively resisting arrest or attempting to evade arrest by flight. Regarding the first Graham factor, the severity of the crime at issue, the court held that it favored Ms. Surratt because her conduct of resisting arrest and obstructing a peace officer were not severe crimes. In Colorado, obstructing a peace officer and resisting arrest are both Class 2 misdemeanors. Although both crimes may be achieved by violent means, taken in the light most favorable to Ms. Surratt, the jury could conclude that she committed both crimes in a particularly harmless manner, where the only physical force she used was attempting to pry Officer Clanzer's fingers off her arm and pawing at his arms. Because these are misdemeanor offenses and a jury could find that they were committed in a non-violent manner, the amount of force used should be reduced accordingly. Here, Ms. Surratt's misdemeanor offenses weigh against Officer Clanzer's use of the takedown maneuver during her arrest. The second factor, whether the suspect poses an immediate threat to the safety of the officer or others, is undoubtedly the most important and fact-intensive factor in determining the objective reasonableness of an officer's use of force. The court must look at whether the officer or others were in danger at the precise moment that they used force. Ms. Surratt did not pose an immediate threat to Officer Clanzer or anyone else at the moment Officer Clanzer slammed her violently to the ground. Instead, it was undisputed that Officer Clanzer held Ms. Surratt by the wrist, she was unarmed, and she weighed 85 pounds less than Officer Clanzer. Although Ms. Surratt used minimal physical force against Officer Clanzer by attempting to pry his fingers off her arm and pawing at him, this did not place Officer Clanzer or others in any immediate danger. And under these circumstances, Ms. Surratt posed a minimal safety threat at the moment Officer Clanzer threw her to the ground, and so the second Graham factor weighs against Officer Clanzer's use of a significant amount of force. As to the third factor, the court evaluates whether the suspect attempted to flee or actively resisted the arrest. Ms. Surratt's resistance to arrest is conclusively established by her conviction. The court has explained that where plaintiff acknowledges that she was actively resisting arrest, there is no doubt that officers are justified in applying some force against the plaintiff. The level of Ms. Surratt's resistance, attempting to pry Officer Clanzer's fingers off her arm and pawing at him, does not justify a severe use of force in response. Accordingly, although this factor does weigh in favor of Officer Clanzer reasonably using some amount of force against Ms. Surratt to overcome that resistance that she provided, his use of force had to be proportionate. Thus, the 10th Circuit weighed this factor as providing support for the use of a minimal amount of force. Thus, as a matter of law, the U.S. 10th Circuit Court of Appeals held that Officer Clanzer in the takedown you see on the video violated the Fourth Amendment. That is undisputed. But the problem with qualified immunity is that it applies in those scenarios where the Constitution has been violated. The issue is whether or not the officer gets immunity. And that's what ended up happening here. Although the court held this was a Fourth Amendment violation, excessive force, they said in April of 2017, a reasonable officer would not have known that using a takedown maneuver such as this to throw Ms. Surratt onto the ground while she was resisting arrest for a non-violent misdemeanor and not posing a danger to Officer Clanzer would not violate the Fourth Amendment, which is sort of insane. She wasn't able to point to a case where the facts were close enough. That was earlier in time than when the incident happened. She put forward 5 different cases, but they were from other circuits, and then 3 unpublished 10th Circuit cases. So one of the cases was Shannon versus Kohler, and in Shannon, when the officers responded to an altercation at a bar, which is similar, the plaintiff strongly stated to one of the officers using profanity that he on the bar did not need the officer and ordered the officer to get out of the bar. The officer alleged the plaintiff poked him twice in the chest. The officer then performed a takedown, which caused the plaintiff to hit a bar stool and land on the floor. But this was the 8th Circuit. The 8th Circuit concluded, though, it was not reasonable for the officer to use more than a de minimis force, bare minimum, against the plaintiff where he was not suspected of committing a serious crime, did not attempt to flee or actively resist arrest, and posed little to no threat to the officer or others. But importantly, the 8th Circuit there concluded that the jury could find the plaintiff Shannon did not resist arrest, whereas here, Ms. Surratt was actually convicted of and admitted to resisting arrest. So that case is distinguishable. And the court basically went through the others, shot them down one by one, You can review all those. I will post the full opinion at the blog. Link below. The point is that the 10th Circuit said none of the precedent, none of the prior opinions identified by Mr. Surratt would have made it clear to every reasonable officer that throwing Mr. Surratt to the ground in response to minimal resistance would violate the 4th Amendment. And as a result, Officer Claimer is entitled to qualified immunity. One silver lining there, this order was entered November 9th, 2022. So from that date through now, anyone who has been thrown to the ground by a police officer in the 10th Circuit in response to what's arguably or alleged to be minimal resistance, they can get past qualified immunity. That this officer got qualified immunity. Just a couple of days ago, it was announced in the media that the city of Fort Collins had agreed to pay Ms. Surratt $300,000 after 7 years of battling this lawsuit in court. But Fort Collins Chief of Police Jeff Swoboda said that was not the city or the agency admitting any wrongdoing. This settlement is a situation where we chose to avoid the continued expense and ongoing disruption of litigation that has ensued over the past 7 years and was unlikely to be resolved even after the scheduled district court trial. Swoboda said the agency always reviews prior interactions with the community to learn, and the agency adjusts its practices when necessary. However, it was not made clear whether or not the agency made any direct changes to its use of force training when it comes to Surratt's specific case. If the officer got qualified immunity, why wasn't the case over? Why wasn't it settled? Well, the reason probably is because the plaintiff also asserted what's called a Monell claim. A direct civil rights violation always has to be asserted against an individual, the individual officer. So that is the defendant in the case. You can sue a city or a county under what's called a Monell claim, but it's not like the private economy where you can sue Walmart for the actions of their employee. Government does not let us do that. You have to specifically allege that there is a unconstitutional policy, pattern, practice that directly caused the event that was committed by their employee. So a very, very tough case to make. Guess what? A city cannot invoke qualified immunity. It's not a defense to a city. But the problem with that is it's very, very difficult to prove. That probably was still left hanging out there. Apparently, that was worth $300,000. The city of Fort Collins, Colorado, as we sit here today, cannot deny that that video shows one of their police officers violating this woman's Fourth Amendment rights. That is the law now. That's the law of the land in Colorado, in the 10th Circuit. The court actually looked at it. They watched the video. They declared that to be an unconstitutional act, slamming that woman down to the concrete. And henceforth, any police officer who does it again will be denied qualified immunity. Unfortunately, the officer in this case got away with it. So when the city of Fort Collins says that we're denying any wrongdoing, notice that they parse the words carefully. They don't say the officer did nothing wrong. They're saying we did nothing wrong. Have they changed anything in their policy? I mean, they defended this guy for 7 years. Did they discipline him? Did they take any responsibility for getting the situation where, you know, a court one step down from the Supreme Court of the United States says that their employee violated this woman's constitutional rights, which supposedly he took an oath to protect. They hid behind qualified immunity for 7 years. They don't admit to have changed anything. Instead, they paid out $300,000. And that settlement amount, in my opinion, is a good one. I mean, the main stronger claim against the officer got thrown out. That wasn't going to trial. The officer was out. So it was the only claim left in is the Monell claim against the city. As I said, those can be very, very difficult. But let me know what you think in the comments. Again, this is one of those situations where, you know, everyone can have their own opinion, but none of this can be disputed. That video shows an excessive force violation. Nobody can dispute that. That's the law of the land. That woman ended up getting $300,000 in the end. That's what happened. Nobody can dispute that. But yet the officer did get qualified immunity here. Nobody can dispute that. It just sort of illustrates the absurdity of the whole qualified immunity doctrine. It does not. So thanks for watching. If you like to go through these sorts of things, please make sure you subscribe and check to see that you're still subscribed. Every day people are telling me that YouTube keeps unsubscribing them. They've had it happen 10 or 15 times.
All right. What y'all think about that? So it took 7 years for this lady to get an answer for what's obvious, that it's obvious that the cop brutalized her. It's easy to see. And when she tried to peel his arms off of her, that's when he slammed her, which is insane. She had nothing to do with the scene or what was going on, but he decided he was gonna throw her on the ground, face forward. It's 7 years. You would think maybe 2 years would be reasonable. I wouldn't even say that, because it's a difference when you have video evidence, when you can see what's happening on video, and it still took 7 years to make a decision. Insane. The fact that it takes years in general is unbelievable. I'm gonna play this video. This is another one from the civil rights lawyer, and this is how cops called my client and took an innocent guy to jail and got sued.
This is my client DJ. He was driving his crappy little farm car to the store to get some feed for the pile of animals he and his wife had at home. But he gets pulled over, even though the only thing he did wrong was not have an inspection sticker on this crappy little car. He ends up getting arrested, going to jail, and being prosecuted as a drug dealer. How did that happen?
Why are you so shaky? Look at your arm. It's trembling. You have anything illegal in the car?
No. Anything illegal in here?
Martinsburg, this county have a canine working today.
It's
Hey, I'm gonna tell
crazy.
you what, Mr. Beard, go step out of the car for me.
I'm not. Did I commit a crime?
Step out of the car. Step out of the car. Martinsburg, send me in here. He's refusing to step out of the car. Get out of the car. Get out of the car.
Now this young rookie cop, only out of the academy about 3 months, thinks he's caught some sort of drug kingpin. He ordered a drug dog even before ordering DJ out of his car. Even though DJ never refused to get out of his car, he's yanked out and arrested, put in handcuffs, and put in the back of the police car. From there, he witnesses this scam that these cops are running.
Can we get a canine strip, please? Yeah.
The supervisor can see that the dog is not interested and he knows what's coming next. So he turns away so his body cam does not capture what's about to happen. But the rookie doesn't know to turn away and he films it. That's right. Even though the dog was not interested in the car, the handler called his attention over, whistled at him, and tapped on the car, then gave the dog a treat when he reacted to the tapping. That's the scam. And the supervisor tells DJ that the dog alerted, but DJ saw what happened.
So the dog gave a positive alert for
I saw him
in the car?
tap up there, but there's nothing illegal. I've never done drugs in my life.
There's
So,
no illegal. Okay.
no,
All right. Now, these doesn't tell us who it was.
no, there's definitely not.
Okay.
That was used as the justification to go through.
That was terrible. Can y'all see that? What do y'all think about that? They obviously scamming him. And think about how many people they've done that to. Insane.
All of DJ's stuff. And while doing so, that same supervisor mocked the whole situation while talking to the dog handler, and they both laugh about the scam they just pulled on DJ and about the fact that DJ saw it, and they don't even care.
I said, canine in the car. He's like, yeah, I saw him tap up there. I'm like, man, shut up.
No, that's actually not what he said. You may remember I did a video on this about a year ago. I asked, should we file a lawsuit? Well, we did file a lawsuit. Just a few weeks ago, I took the depositions of this officer and also the young arresting rookie officer. And that answered a lot of questions about how this innocent guy got dragged through this whole thing. and wrongfully arrested and wrongfully charged. I'll show you what the key violations are, because this could happen to you or someone you love, and you need to understand your rights. Fighting for justice often means that I'm on the move. Recently, I found myself in a bit of a bind while traveling. Picture this, I'm out in the middle of nowhere. My phone's data roaming is off the charts expensive, and there's no Wi-Fi in sight when I needed to make an important security. Setting it up was a breeze. The app didn't connect QR code. Using Safe World Security, 1,000 of you will get a one trip or even peace of mind. Check the description for the link, use the code CIVIL, and join the Saley family. Safe travels, and now let's get back to the video. This stop happened in Martinsburg, West Virginia. A young police officer with the Martinsburg Police Department pulled DJ over in this mattress store parking lot. It was a lawful stop because the crappy little farm car that DJ was driving, in fact, did not have a valid inspection sticker, which is required in West Virginia.
Hello, I'm Officer Smith. I stopped you today, man. You got no inspection sticker on your car.
Yeah, I know. We're working on it.
Okay.
Here, the exhaust.
I do. I got you. You got your license, your registration? Why are you so shaky? Look at your arm. It's trembling. You have anything illegal on the car?
No. You got anything illegal in here?
Even though this traffic stop right now is completely legal, because there was reasonable suspicion that there was a violation, and that was the lack of a valid inspection sticker. It's still a seizure under the Fourth Amendment, and the Fourth Amendment requires that any seizures be reasonable, both lawful at their inception and also reasonable in relation to the actual purpose of the seizure, the purpose of the stop, the inspection sticker. Here, despite there being a lawful stop, it goes terribly sideways because this young officer immediately pivots from investigating an inspection sticker to all of a sudden a drug investigation. It all seems to have begun with this bizarre question, why is your arm shaking? When it clearly is not shaking, we can see from several views.
Why are you so shaky? Look at your arm. It's trembling. You have anything illegal on the car?
Now, at the officer's deposition, I asked him, what part of Mr. Beard's body did you observe to be shaking? He said specifically his left hand, whereas in the video, he said arm, and he appears to have pointed at the right arm, which is the only possible appendage that could have been shaking.
Look at your arm. It's trembling.
And then he asks him if there's anything illegal in the car. And DJ listened to it. He actually says no. And then asks, do you have anything illegal on you?
You have anything illegal in the car?
No. You got anything illegal in here?
So he answered the question, said he did not have anything illegal, and then he, using sarcasm, criticized the officer for asking him a dumb question. Now, they are allowed to ask questions that are unrelated to the reason for the stop, so long as they're not prolonging the stop or extending the stop with these other unrelated questions.
You have registration insurance on the car?
Yeah, good.
Okay, I need to
Just
see
run
those.
it, because I don't think it's in here. So, I mean, we can check.
Martinsburg, does county have a canine working today?
This is important. Even before the officer ordered DJ out of the car, he called for the drug dog over the radio.
I mean, we can check.
Martinsburg, does county have a canine working today?
That's significant. When I asked the officer at his deposition, what was it about this traffic stop that made you want to order Mr. Beard out of his car? His answer was this. Really, I guess the totality of the circumstances. Everything from me seeing his arm being shaky, not wanting to give me his registration, or even attempt to locate it for me. Him searching the glove box made me uncomfortable because I couldn't really see over into the glove box what he was reaching for. But you just saw in the video that DJ never refused to give his registration. He said he didn't think he had the registration, but that he would look for it. Then as he said he would look for it, he opens the glove box clearly to look for it, and he begins to look for it.
You have registration insurance on the car?
Yeah, good.
Okay, I need to
Just
see
run
those.
it, because I don't think it's in here. So, I mean, we can check.
Martinsburg, this county have a canine working today.
So it's not true that he refused to give his registration. He was in the process of looking for his registration, which had been requested. He was trying to comply. Commonly, we keep our registrations in the glove box. But now this officer, after the fact, is claiming that the reason he wanted him out of the car is because DJ was searching around in his glove box, and that was suspicious to him. It made him feel unsafe. Clearly, the video footage does not match up with his sworn testimony.
Hey, I'm gonna tell you what, Mr. Beard, go and step out of the car for me.
Did I commit a crime?
Step out of the car. Step out of the car. Martinsburg, send me another unit. He's refusing to step out of the car. Get out of the car. Get out of the car. You're under arrest for obstructing. You're under arrest for obstructing. I told you to step out of the car. I told you once.
What crime did I commit?
You don't have to commit a crime if you have to step out of the car. Give me your other hand. Give me your other hand.
You can't just
Give me your other hand. If you're videotaping, that's fine. I'm videotaping too, man. When I asked you to step out of the car, you're required by law to step out of the vehicle. When I asked about it, negative.
I asked what crime I committed. I'm not to ask what crime I committed.
I told you I stopped you for dead inspection. Well, no inspection, actually.
Pull somebody out of the car with.
You're acting very nervous. You're shaky. For my officer's safety, that's why I had to step out of the vehicle.
I got a very hurt horse.
Look how crazy this is. And this is what it turns into. Very often. And you would think this, you wouldn't think that this happens more times than you think it doesn't. And imagine all the people who they take to jail because of situations like this. Unbelievable.
25 with him.
This is crazy.
You have any weapons on you?
No, mine.
Yeah, I'm scared. Look, man, you turned this into something you didn't need to be, man. All I was doing was asking for your
And I'm just asking. I have nothing to hide. I have nothing to hide.
The cop says, you turned into all this because you asked questions. Just think about that. How did that make you feel? What the cop is saying and what he's doing right here.
Not at all.
All right, well, I told you what's going on. I stopped for inspection. So
I understand
when I asked you to step out of the car, you have to step out of the vehicle.
Okay,
You have to step out of the car.
I disagree, but
I know you may disagree, but that's the law. You get what I'm saying? Spread your feet. All right.
This officer later told the canine handler from the sheriff's department, who subsequently arrived, when he asked him, what did you arrest him for? This is what he said.
What did you arrest him for? So I said, step out of the car. I didn't commit a crime. I don't need to step out. Step out of the car. I don't need to step out. Okay, you're under arrest. Obstructing.
So he tells the canine handler that DJ said twice, I don't need to step out. No, I don't need to step out of the car. Let's look back at what actually.
That's not what happened at all. Not in the least bit.
Happened.
Hey, I'm gonna tell you what, Mr. Beard, go and step out of the car for me.
did I commit a crime?
Step out of the car. Step out of the car. Martinsburg, send me another unit. He's refusing to step out of the car. Get out of the car. Get out of the car. You're under arrest for obstructing.
Let's look at his police report. So this is the narrative that was included in the charging document that is submitted under oath to the court by this officer. And this is what he wrote in that report. Mr. Beard refused to exit the vehicle and told me he did not commit a crime and would not exit the vehicle. But the video shows that DJ did not say that. He questioned the officer's authority, but did not refuse to get out of the vehicle. He was basically yanked out very quickly.
Let's say what crime I committed. That was all.
I can have anybody I want step out of the vehicle. Okay, I'm not doing this
I
with
don't
you.
think that's
All he's telling you is that he asked the question and wondering why he's under arrest right now. Any normal person would. But the fact that they keep hiring people like this, cops like this, you wonder what is the process? What is the interview process of hiring one of these people?
Okay, well, this is my lieutenant. Feel free to ask me any questions you feel you need to.
I just asked what crime I committed to be taken out of the car. That was all.
Pennsylvania versus them says we don't have to tell you. We can take you out of the car for any reason
I know
whatsoever.
your case law it said not, but that's all I was asking as well. I was asking to be sent out of the car for
I just provided the case law to you.
for that. That was all.
Move it to your way. All right, buddy. Walk back to my car.
We see that the key word here that they've been teaching cops is Pennsylvania versus Mims, and they like to use that word. But it's always apparent that they never actually read that case. They never actually learn the case law pertaining to Pennsylvania versus Mims, because Pennsylvania versus Mims only means that this officer can still perform his routine traffic stop, but just with DJ standing outside of his car rather than sitting inside. Whereas the officer in this case appears to have been misusing Pennsylvania versus Mims to engage in a drug investigation where he's pulling the individual out of the car and frisking.
So in this video, it was a rookie cop, but the thing is, this is how they, whether it's a rookie or senior, or whether it's rookie or senior, it's the same thing. It's along the same lines. You'll find sergeants like that. You'll find lieutenants like that. It's just unbelievable. Whether you're a rookie or not, he knows that nothing about this was right. He knows that.
Him. Pennsylvania versus Mims does not allow for that. So remember, the traffic stop that was supposed to be occurring was for the inspection sticker issue. I asked him at his deposition, at any point, did you actually begin the process of issuing a warning or a citation for the inspection sticker issue? He said, I believe I did. When? When was that? Answer, I believe it was after he was already arrested. So there was no routine traffic stop occurring. He also admitted during his deposition that in a routine traffic stop for an inspection sticker, he would not pull somebody out of the car. He'd get their information and then he'd go back to his car and he'd write the ticket. None of that happened here. But what did happen, and remember I told you this would be important, he had already called for the drug dog prior to ever ordering him out of the car. And it's no wonder that DJ was surprised by this and wondering, well, what crime did I commit that you're ordering me out of the car? He was being suspected for some sort of drug crime and not for any legitimate reason. His police report says that he arrested Mr. Beard first, and then he called for the canine. When I confronted him about that at his deposition, he said he admitted that was false. I said, so the part of your report that says you arrested him for obstruction and then you called the canine, that's false? He said, yeah. Yes, sir. That was a mistake, a typing mistake. After discovering that you had made that mistake, did you ever go back and correct the narrative? No, sir. To be truthful, I didn't know that the narrative was inaccurate until, I guess, past when I would be able to go back and fix it. The point is that this is one of the scams that cops run. If you express any criticism of them, or if you question their authority at all to do something, which you have a First Amendment right to do according to the Supreme Court, they are going to retaliate against you. And this is one of the main ways where they can do that. They know that they have this right to get you out of the car during a routine traffic stop, Pennsylvania versus Mims, but they take it to another level that they're not allowed to do. And they do it very quickly. And what happened to DJ happens all the time. If they perceive any disrespect, any pushback, any questioning at all, they go ahead and order you out of the car and then very quickly, physically and forcibly pull you out of the car, really not even giving you an opportunity to refuse or to get out. This is them abusing that Supreme Court holding to, under the guise of officer safety, to perform a false arrest. So that's what that's the goal is. either to retaliate against you, we're going to do this the hard way now, or to set up an arrest. Oh yeah, he didn't get, and we can see how that happens because as soon as the other officers arrive, he says, "Oh yeah, well, he repeatedly refused to get out of the car." And on the police report, "Oh, he said I'm not getting out of the car." And thank God the body cam footage shows the truth, and that's why there ended up not being any conviction here because the police report was false. I mean, it had a lie in it. It had a false statement in it. What he said at the scene was false. That was a lie. That did not occur. He was wondering why he was having to get out of the car when he was supposed to be in a traffic stop for an inspection sticker. This man had no chance to get out of his car. This had nothing to do with an inspection sticker. This was just pure retaliation. And you can see that to prove that, you have to go into the weeds and nail these people down like happened here. All right, so here's step 2 of the scam that not only happened to DJ on this occasion, but happens all over the country every day. The scam is that cops bring a drug-sniffing dog to the scene. What they need to search your vehicle is probable cause. The courts have said that if this trained drug-sniffing dog circles your car and signals that there's narcotics in the car, that is probable cause to then search the inside of your car. This is what they want to do. And as you'll see, they're not going to take no for an answer from the drug-sniffing dog.
Well, see, he was shaking horrible. So I was like, anything illegal in the car? And said, "Do you have anything illegal on you?" And I was like, "Oh, do you have anything illegal in the car?"
No. You got anything illegal on you?
I was like, anything illegal in the car? And said, "Do you have anything illegal on you?"
So Cole, we get a canine sniff, please.
Yeah. What's
You
that?
want them closed?
Oh, close them. I thought you could open them.
All right, here comes the drug dog. Notice that the dog is not at all interested in DJ's car. In fact, he's running towards the police car. But after the dog shows little interest, you see how the scam operates. The handler whistles at him and basically pulls him to the passenger side door where they know DJ's backpack is sitting on the seat. They've just had the doors open, so the smell's wafting around. Finally, the handler just has to tap on the car and signal to the dog that he's supposed to do something. Then the dog signals, which presumably is sitting. And then he's given a treat for doing so. Clearly, the dog was responding to that and didn't smell anything in DJ's car because there wasn't really anything in there. Though that didn't stop the cops. The supervisor, the lieutenant, sees what's happening, that the dog is not interested. He knows what comes next, and so he turns away so his body cam does not capture what happens. The rookie, only on the job 3 months, just stares right at it, and we get to see what actually happened. And of course, that didn't make it into the report either. Then the lieutenant, who perhaps wisely wasn't looking when the dog, quote unquote, alerted, went over to DJ and says, "Yeah, well, you probably saw that the dog alerted. What are we going to find in your car?" DJ's confident that they're not going to find any narcotics in his car. And DJ calls them out on the fake dog alert.
I'm sure you just saw a dog. So the dog gave a positive alert for
I
presence
saw you
signs in the car.
tap up there, but there's nothing illegal. I've never done drugs in my life.
There's
So,
no illegal. Okay.
no,
All right. Now, these doesn't tell us there was.
no, they're definitely not.
Okay.
Now, with their supposed probable cause, they completely toss DJ's car. The lieutenant himself searches through all of the contents of DJ's backpack, which he's been carrying around for a long period of time, and it just has all sorts of stuff in it. It has all his medications, it has past medications, it has over-the-counter stuff in it. And the goal is to not even just find something illegal, just something that they can say looked illegal so that they can arrest and prosecute DJ as some sort of drug dealer. It doesn't matter if you end up beating the charges. It's about putting you through the process. That is the punishment.
See one of these little shit boxes for a while.
That's wild. What do y'all think about this so far? Again, you have them in the wrong, doing everything wrong, and they know they should be doing something different. But hey, it's part of the training. When they hire these people, who's doing the hiring process?
Well, I got your bag, sir.
So they took him out the car. Now they're going through his stuff for no reason, because basically because they're tyrants, and it's unbelievable. They're not going through his stuff.
So the lieutenant is searching through this bag. The officer standing in front of him is the canine handler. And now there's a discussion regarding the canine alert scam. This sounds an awful lot like me to an admission that it was a scam. There was no alert. That's why they're laughing about it.
Canine in the car. He's like, yeah, I saw him tap up there. Like, man, shut up. No, he's P525.
So we see they illegally going through his stuff.
So, hacking. So where's the pallet? Right here. Appreciate that.
You are testing all these, or are you sending them out?
We might actually get the, yeah, I might get a task force come down here with their thing before we send it off.
And that's what they did during the arrest processing, is they had the drug task force come and do field testing on whatever suspicious substances they found in this backpack full of stuff. Nothing tested positive for being narcotics or anything illegal. They still ended up sending some of it away to the West Virginia State Police State Drug Lab. None of it, of what they sent, tested positive for anything illegal. They said they found some marijuana tar. They never bothered to test that. To make a long story short, there was no proof that there was anything illegal in that car, yet they arrested him, took him to jail, all that, and charged him with basically being a drug dealer. With not only that, but intent to deliver. I mean, they threw everything at him that they could. He had nothing illegal. When the results came back, the prosecutors dropped all of the drug charges, and ultimately the obstruction charge was dropped as well because it was completely bogus, as evidenced by the video footage. So remember, just because you did nothing illegal, that does not mean that the cops cannot arrest you and cannot treat you like a criminal and cannot drag you through the criminal justice system where months, maybe years later, your case gets dropped when drug tests finally come back. Well, it looked like drugs. However, we didn't know. We're not scientists. And it's just unfortunate that DJ had to go through this when all he did was not have a valid current inspection sticker on this crappy little farm car that he was using to go get feed for his animals. His only real crime was questioning the authority of this police officer who's been on the job for like 3 months, and he was working at Chick-fil-A before this. Like, I kid you not. And now he doesn't even work for the same police department. He's been hired by the West Virginia State Police. So go watch both of my last videos, both of which have to do with the West Virginia State Police. And I think you'll see how you get these problems. You get these sorts of people who are tyrants from a young age. So we filed a lawsuit. We made it through most of the discovery stage. We've taken depositions. Next, there will be dispositive motions to the court. If you want to follow along, subscribe both here and at the blog at thecivilrightslawyer.com. Follow me on Twitter at JohnBryanESQ. I'd like to hear your thoughts in the comments about the drug dog. Did that look like an alert to you? Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.